afternoon. These are public hearings for code enforcement violations. These hearings are quasi-judicial. I am the special magistrate appointed to hear these cases. Formal rules of evidence do not apply, but fundamental due process shall be observed. Everyone who has a case today will have an opportunity to present testimony. You may present evidence or witnesses to testify on your behalf. There is no public comment portion. You must be a respondent or be called as a witness in order to speak on a specific case. Everything today is being recorded. All testimony is under oath. When you are sworn in, please provide us your current mailing address so any orders get to the right place. The city will present its case first and information will be displayed on the screen. The city's PowerPoint presentation will be entered into evidence unless any objections are made. After the evidence, I will make a ruling. That ruling will be reduced to writing and mailed to you. At this point, I will swear in the witnesses, and anyone who is here to testify about your case, please raise your right hand so I can swear you in. If you're going to testify, please raise your right hand. You can just stand right there and I'll swear you in. Raise your right hand and do you swear or affirm that the testimony you give is the truth, the whole truth, and nothing but the truth? Thank you. Before we start our first case, I'm going to bring up case number 23-39, which is City of Titusville versus Vermont, LLC, 1545 Kings Court is the property. This case was heard, I believe it was Officer Flanagan's case. This case was initially heard on July 10th. And for some reason in the order, there was language in the order that said the respondent had to get a demolition permit, but it was a case about a stagnant pool. So that was brought to my attention, and I am entering today a corrected findings of fact, conclusions of law and order, which I've already sent a copy over to the city and signed by me as of today, eliminating that requirement that the respondent obtain a demolition permit. It's a stagnant pool and the respondent needs to clean up the pool. I did go ahead and give the respondent an additional 14 days from today. 14 days was what we originally provided to the respondent, and 14 days from today, and if it doesn't get cured by then, I guess we'll see it at the next month's hearing. So that is the corrected findings of fact, conclusions of law and order, and the new compliance date is September 25th, 2023. And ready whenever you are.
Yes, ma'am, if we could, Kyle Mack, Fire Inspector, has some training he has to attend, and if we could push him up to the very first one, and then we can get right into the rest of the hearings, ma'am.
Sounds good. I know he doesn't want to miss his training.
Yep, and it is case number 2350. And Kyle Mack, Fire Inspector.
Hello, long time no see.
No.
All right, so I have got the notices of violation, hearing, and the cost recovery for you.
Thank you. All right, I will go ahead and enter into evidence as Exhibit 1 is the notice of violation and affidavit of service. Exhibit 2 is the notice of hearing and affidavit of service. And Exhibit 3 is cost recovery sheet, requesting costs in the amount of $128.53. So admitted.
go. All right, so case 23-50 is going to be respondent Orca Properties LLC. The violation address is 4265 South Street, Titusville, Florida 32780. Mail to address was 391 North Babcock Street in Melbourne, Florida. This particular case is a response to alarms, corrective actions, and reports required. Did you have
Yeah, ma'am, if we could, the owner of the property is Orca Properties. However, in this particular incident, we're going to be referring to Appliance Direct
Okay,
as a respondent.
The building, I guess, is owned by Orca Properties. It's leased to Appliance Direct as a warehouse.
okay,
So, response to alarms, basically the fire alarm went off enough times during the 9-month period to initiate a fire alarm fine, and they never actually paid this particular fine, causing me to write them up for not paying the fire alarm fine. The initial inspection was 6/16/23. I delivered the report to the actual showroom in Port St. John. The warehouse here in the city is not routinely staffed by employees, only when they have some sort of delivery or shipment. So I just took it to the office there in Port St. John. That's staffed I don't want to say 24/7, it's staffed continuously.
okay.
Date given to comply was 7/16/23. Mailed certified was 6/19/23 and was delivered 6/26 of the same year, signed for by the agent. Notice of hearing was 8/10, posted on City Hall and the property where the violation exists, certified mail 8/15, and again signed for on 8/17. The only contact I've had with either Appliance Direct or it's only Appliance Direct. I haven't actually had any direct contact with the Orca Properties. But I spoke with the manager at the Port St. John location, informed him what the issue was, presented him with a copy of both the code enforcement violation and our written fire department inspection report, just detailing the issues. He said he would forward it on, and I haven't heard anything else from them after that date. As I said, business location has had several false fire alarms, and as of last Thursday, we had not received any of the false fire alarms. Our fiscal analyst is currently out today, so I wasn't able to check with her today to see if we had received it, but I don't think that we have.
How much is it?
The actual false alarm itself is $290, and then the cost recovery was $138 or so, I believe. And then $290 is just the standard false alarm fine for the department. All they need to do is just contact us at the fire department, and we can walk them through how they can pay the fine off. They've actually had to pay a couple of fines from us, so they already know the process.
So they know
Yeah.
how this
Yeah.
goes. Okay.
We've had issues with this alarm before. They're actually in the process of putting a new one in, so we're kind of hoping that once they put the new one in, it'll kind of relieve the issues we've been having.
Okay.
Recommendation, I would just ask that they correct the violation on or before October 10th of this year, and simply pay the fine in full, $290, and then the administrative fees would be assessed in the amount of $128.53. They can reach out to me at my phone number, email address, or they can simply reach out to the fire department's main line, and we can help them through the process.
Okay, and they are not, no one is here today representing that respondent?
I don't believe so.
Okay. So the fines for, the false alarm fines is $290.
Yes.
And then the city's costs that are being requested is $128.53. All right, having heard the evidence and testimony, I find respondent was provided notice of the violation and notice of this hearing. That respondent or any representative is not present today. The evidence shows that the respondent is in violation of Section 3-13, response to alarms, which requires fines for a certain number of false alarms. This amount was due to be paid by respondent, but it has not been paid after due notice. I find that the respondent shall comply by October 10, 2023, and compliance shall be achieved by paying the amount of the fine of $290. Do you have it just has to be paid by that date. So anytime between now and
Yeah,
that
that would be fine.
date.
They just need to, I just recommend it before the next meeting.
Okay, and if they don't pay by that date, I can't really assess a daily fine or anything.
I don't believe so, but, I mean, we can,
No, we're just asking for the fine in
Just for
in
the
this matter.
fine.
Yes, ma'am.
Okay, and then the city's costs of prosecution in the amount of $128.53 shall also be imposed. Anything else on that one?
that would be it.
You better get to your very
Excellent.
important training.
Wouldn't want to leave everybody waiting. Thank you very much.
Okay.
Yes, ma'am, and that takes us back to the start of our Massey hearings.
All right.
Our very first one, the R.W. Kirk Family Limited Partnership. I'm glad to say that they are in compliance and their costs have been paid.
Great.
Then you read in the new order allowing for an additional 14 days on the next case.
Yes, I guess I should have waited for the case to be called up. I just wanted to get that
Yes,
taken
ma'am.
care of on
Oh, yes, ma'am.
2339.
Yes, ma'am.
Was there any additional testimony we needed
No,
on
ma'am.
that one?
No, ma'am, they were not present that day.
Okay. And they're not present today?
Today, no, ma'am.
Okay.
And that takes us to case number 23-46, Tommy L. Pouncey Estate, 918 Weiger Avenue. And the officer in this is Jim Flanagan, who's prepared.
Good afternoon. It's
Good
2346, 918 Wagger. First thing I have is the notice of hearing for today.
All right, Exhibit 1 will be the notice of hearing for today's hearing, admitted into evidence.
Okay. This is the respondent is Tommy Pouncey Estate, 918 Wagger Avenue. It was mailed to 1376 Jackery Avenue, Holly Hill. The violations again were junk and debris, accessory structure for the fence, and window skylights and door frame. This case was originally heard on August 14, 2023. The respondent was given until September 8th, 2023 to correct the violation. If compliance with all violations is not achieved, the magistrate requested a fine of $50 per day per violation commencing on September 8th until the violations are corrected. And the administrative costs were $163.75.
Oh, is it wrong in the agenda then?
Hmm?
I think the agenda says 11092.
The cost was 110.92.
110.92 is correct. My apologies.
Okay.
I was gonna say, I didn't think it's-
That's what was submitted last month, 110.92.
Okay. All right.
The violations of the hearing were posted on the property in first class mailed. The estate owner of the property was here last month and gave her the information. She did not stay present for the hearing. She understood what was going to happen, just didn't want to testify to anything due to other issues going on with the property. These are the original pictures of the junk and debris on the property. This is the fence on the side of the property that was falling down. The original pictures. This is kind of hard to see. This is one of the broken windows that were on the property. And this is more junk and debris of the updated for the case last month. I just wanted to give you the pictures on here and everything. This is more of the debris just before the case was heard last month, and more debris that was on the side of the property. And when I went back out to the property today, the same thing, the violations are still present. Nothing has been changed.
On
Nothing has
on
been
each
corrected.
violation?
On every violation, correct. The fence is still damaged. There's still debris in the yard.
Any new debris, or does it pretty much look like the same?
It's different debris. I'll give it that. It's, but there's still debris and junk in the yard.
And the window?
The window's still broken, yes.
Respondent is not present or is present?
No.
Okay. Based on the evidence and testimony, I find that respondent was provided notice of today's hearing but did not appear. I find that respondent was supposed to have brought 3 violations into compliance by September 8th, 2023. And based on the testimony, the violations have not been brought into compliance. All violations still exist. Fence is still damaged, still debris, junk and debris in the yard, and the window is still broken. Therefore, respondent did not come into compliance by the date set forth in the previous order, and fine in the amount of $50 per day per violation shall be imposed, as well as the costs in the amount of $110.92.
Yes, ma'am. Our next case, 23-49, Dana Carter, 2196 Heritage Drive. And the case inspector, and this is Ken Hutchins.
Good afternoon.
Hello.
I'd like to first submit for evidence the affidavit for notice of hearing.
Admitted into evidence as Exhibit 1 will be the notice of hearing for today's hearing and affidavit of service.
All right, just a quick recap. The respondent's Dana Carter at the 3130 Silver Falls Drive, Kingwood, Texas is the owner. And the violation address is 2196 Heritage Drive, obviously here in Titusville. Everything was mailed to 3130 Silver Falls Drive in Texas. And the violations were IPMC 6109 and 304.1. That was general exterior maintenance. And 304.13, which was the windows. This case was originally heard on 8/14 of 2023. Respondent was given until 9/8 of 2023 to correct the violations. If compliance of violations was not achieved by the given compliance date, the magistrate may impose a fine of up to $25 per day per violation, commencing 9/11 of 2023, and continuing daily until violations are corrected. The respondent also be assessed administrative costs in the amount of $146.14. And notice of hearings, 8/28/2023, posted at City Hall and on property where the violation exists. Certified mail was first class, and 8/21 of 2023, returned not signed for. And I've had no communication with the property owner.
Is there anyone living in the property?
Not that I'm aware of.
Okay.
Again, these are some of the pictures that were originally taken when first presented. The window, and as of this morning, everything still remains the same. Windows are still broken. This is 304.13. It goes into windows, skylights, door frames. This particular we're pointing out with regards to the broken window. And this was a picture of the damage of the exterior. Issues with the clay roof, along with the soffit separating from the fascia, remains the same this morning when it was checked on. And the conclusions is that both general exterior and window violations remain in violation as of this morning.
Okay. Is anyone here on this case?
No.
Okay. Based on the evidence and testimony presented, I find that the property owner was provided notice of today's hearing but did not appear. I find that the respondent was ordered to come into compliance by September 8th, 2023, or a fine of $25 per day per violation would be imposed. Respondent did not come into compliance by September 8th, so a fine in the amount of $25 per day per violation shall be imposed beginning September 9, 2023, which shall continue until all violations are cured. I will impose the city's costs in the amount of $146.14. Thank you.
Thank you.
Yes, ma'am. This takes us to our last case, 23-52, which is an initial case. James M. Hanley, who I believe is present today, as well, and the address 7 Lamone Avenue, and Inspector Jim Flanagan.
Okay, good afternoon again. This is case 2352. I have to present notice of violation affidavit, the notice of hearing affidavit for the postings, and the cost recovery for $216.58.
I've been presented with notice of violation and affidavit of service, which will be Exhibit 1. Exhibit 2 will be the notice of hearing and affidavit of service. Exhibit 3 will be the cost recovery sheet seeking costs in the amount of $216.58.
The respondent, again, James Hanley, the violation address, 7 Lemoyne Avenue, Titusville, Florida. The mail to address, 2310 Unity Drive, Edgewater, Florida. The original violation, 1223, junk and debris, and 1373, inoperative vehicles prohibited. Just want to note the junk and debris has been corrected prior to today.
Okay, good.
So we're just talking about the operative vehicles. The initial inspection was on April 17th is when I noticed the violation. Date given to comply was May 3rd. Notice of respondents were mailed on April 18th as well. Notice of hearing was posted, and the only contact I had the owner was once. I received a voicemail stating he was in the process of evicting the tenants, so I gave them additional time. There's been no activity. They're still on site. And then until today when he showed up, that's the first time I haven't talked to him. I observed vehicles on the property that were unregistered and appear inoperable. I also observed junk and debris on the side of the yard. Again, that's been corrected. And the vehicles do remain on the property. This is one of the vehicles that I observed in April on the side of the house with no tag on it. This is a vehicle that I observed on the street on the same day, also with no tag on it. These are the follow-up pictures of last week when I was posting the property. The vehicle does remain on the side of the house. And when I went by there this morning, it was still on the side of the house with no tag. This vehicle was the one that was on the street. It was backed in the driveway, and you can see it still has no tag on it, and I believe it's had a flat tire as well. And as of last week, and as of this morning, it's still on the property. It's been corrected. Again, the conclusion of facts, vehicles without tags being stored on the property improperly. And the recommendation, the order to respond to correct a violation on or before October 6th. In order to correct a violation, he must either repair or register the vehicles. Only one vehicle can remain on the property if it is stored in a fully enclosed structure or stored in a carport with proper cover. In order to respond to the administrative cost of the $216.58. If the respondent does not comply by October 6th, they requested a $50 per day for the violation until the violation is corrected. And to contact me for a follow-up.
Okay, so they need to register whatever doesn't have a tag, fix whatever
Right.
needs to be fixed to make them operable.
Right. The code states you only have one vehicle, and in order to come into compliance and allow the vehicle to be there, that's what they need to do to get it taken care of.
Okay, thank you.
Okay?
Would you like to speak on this case? You could come up and tell us your name and your address.
What do you,
Yeah, you're good.
you just talk? You'll like my response. I have no, I'm not going against it. I would love for those people to, they're guilty of what they're doing. That want the car, that's the gentleman that lives on the left side. It's a duplex. And that's his car. I thought it was the other guy's car next door. But the one on the right side there with all the junk outside, I am suing them and having them thrown out of the house, but it's not happening. It's just, they won't leave, they won't do anything. So I just told my lawyer, so he's fighting it, and they still haven't gotten out of the place. And I can't legally take the garbage, the things on their porch, and put them out to the road myself. If you tell me I can do that today, I'll do it, but
Let me just get your name and address real quick so I know who you are.
James Hanley, Hanley, 2310 Unity Tree Drive, and that's Edgewater, Florida, 32141.
So the officer testified that the junk is cured, that's been fixed. So they must have cleaned up whatever needed to be cleaned up.
Well, and then the picture was there.
I think that was an older picture.
That was an older picture.
Yeah.
That was an older picture. I just left it in the PowerPoint. I just didn't take it out of the
I
PowerPoint.
took
But
pictures myself. Which,
the debris been removed. It's just the vehicles we're talking about today.
oh, yeah?
Yeah.
So it's just the
that's
one,
the other tenant
the
then.
one violation of the vehicles, because I guess it looks like one doesn't have, it's got a flat tire,
Right.
and neither one of them have
Right.
tags.
And on the phone with him, I found out that he was letting me know if they moved out, because my lawyer said don't go there until it's settled. So I haven't been to the house. So he told me blah, blah, blah. And like, as you're saying here, that's the first time I heard, this was yesterday, when I talked to him on the phone, he said, oh, that's my car, the guy next door. I thought it was all their junk and their car and everything else, so. But I have no objections to paying whatever it is.
Well, I don't need you to pay anything yet, because you're gonna get a little bit of time to put the pressure on your tenants to get those cars either removed from the property or tagged. the officer has suggested until October 6th for you to get,
Hopefully, the other people will be out.
what stage are you in with the eviction? Have you actually filed the lawsuit yet? Yeah.
Yes, and they're still not out. Now, like that apartment was completely refurbished, the whole place. Everything was immaculate, and I hate to see it now when I go back in there, but
Well, that's another issue.
it's, yeah, being a landlord.
Right now, we just need to get those two black cars, either removed.
Were they different cars, or was it the same car?
Yeah, talking to the microphone. There's two different vehicles
Oh, yeah.
on the property. Since I don't have access to the VIN numbers, I can't just walk up and check the VIN numbers. They have no tags on either one.
What different brand? They're both black cars,
Yeah, mhm.
but they were different.
Yeah. I think a Volkswagen and a Saturn, I think they were.
So they just need to get those gone, or tagged and operable.
Right.
If there's a flat tire, then they need to fix the flat
Well-
tire.
Well, he's easy to deal with, the guy that you're saying it belongs to the car, so I know he'll do it. I'll make sure he does it, or at least get the car off the property totally. He owns a fix-up car place. He's a mechanic and works on the cars, and he had told me 2 days ago he was gonna get that car off the property. But I thought he was doing it for the neighbor, but it's actually his car, I'm finding out now, so.
Okay, so two cars, either remove them, get them tagged, and whatever needs to be repaired to be operable, that needs to be done, and by October 6th. So we got a little bit of time to put some pressure on the tenants, so I'll go ahead. Do you have any other questions at this point?
No, as long as I was just, I had a stroke, and this is just aggravating
Yes,
things.
yes, I'm sure.
But,
You don't
um,
want to deal with this,
It's,
tenants.
but we've been landlords long enough to pay, it doesn't bother me as long as they leave the premises and I can have my property back and start all over again with somebody else.
Yeah. Okay, I'll go ahead and find that there was proper notice given that the respondent, Mr. Hanley, did appear at the hearing. Based on the evidence and testimony, there are vehicles on the property that are not tagged in violation of Section 13-73, inoperative vehicles prohibited, at least one of which looks like it doesn't have a functioning tire. The respondent is ordered to come into compliance by October 6th, 2023, by bringing the property into compliance. And that means either removing the cars that don't have tags or getting them both registered and repair whatever needs to be repaired to make that an operable vehicle.
Who do I contact?
You will contact, as soon as that is done, you will contact Officer Flanagan to let him know as soon as possible that you've got that taken care of with both cars. And the vehicles need to be parked in the appropriate location as well. If the violation is not corrected by October 6th, there will be another hearing.
Right.
And most likely in November, where you'll come back before me and the officer will tell me if it's been brought into compliance or not brought into compliance. And you can appear as well to tell me what you've done to bring it into compliance. But at that point, it's pretty much beyond my control. If the cars aren't taken care of by October 6th, a fine will start to run in the amount of $25 per day for each and every day that the violation continues past October 6th. So starting October 7, $25 per day, as long as those untagged cars are there. And then the city's cost will be imposed in the amount of $216.58. And any questions, please contact Code Enforcement Officer Jim Flanagan and let him know as soon as possible when you get that taken care of.
The only other thing, when I get these things in the mail saying, something's wrong from code enforcement, I respond on the phone. I have never once got a reply from anyone.
Okay.
Then I get another letter and I call them, tell them what's going on with the eviction. Never get a response. I went to the police station down here.
Mhm.
They put a little box outside and you push the button. I thought someone was going to come out. Nobody comes out. They tell you to call them also. I can't get any connection. I love what he's doing, watching out for my property, actually, because that's, I can't see it from Edgewater.
Right.
But I thought we would come in here because I didn't respond or something, and I'm like, I keep calling, but nothing. I get no one calling back.
I can't really address that. What seems to me, the officers are all very busy. I don't know if they get your messages or not. So that's a different
Yeah.
issue.
I can address that. We actually record all the messages that come in, so I'll review them and I'll see where they're at.
Okay.
Yeah, it just tells the story of, that we're evicting them. So just, calm down and they'll be gone and
Yes,
it'll be fixed.
I'll review the call.
Well, the only point is sometimes evictions take a long time, and I wouldn't blame the city if they didn't want to say, okay, we'll wait until your eviction is fully done before we
Well-
pursue this. But that's the city's decision.
Yeah, but if they could give me the okay, I would take this stuff off, well, he said it's gone now, so that's one positive thing. But,
There may be other solutions on the untagged vehicles. I don't know that there may be other solutions.
Well, it's all good.
Okay.
I appreciate all the things you are doing. Like I say, my wife and I were partners in the whole thing. We were married 50 years, but she passed away. And then my son was killed.
Oh, no.
And then I had a stroke. So here I am.
It's not been good.
We're still hanging in there.
It's not been good.
And,
Well, keep hanging in there.
yeah,
You will get an order in the mail saying basically what happened today.
and I pay you something now, you're saying? Do I have to pay something now?
Well, there are costs, $216.58. That's their costs for bringing the case forward.
And I pay
but
that how?
that you can talk with the assistant city attorney about.
I brought money.
I'm sure they would be happy to take any money. All right, anything else from code manager?
No, ma'am.
All right, then we are adjourned. Thank you, sir, for coming.